The Supreme Court bolstering mobile phone privacy. Justices had considered this idea that prosecutors would have to get a subpoena or a warrant in order to sequester information from telephone companies. And I guess it was an expected decision, David.
Well, I don't know, because they hadn't really addressed this issue, because of course they're not actually getting the content of the telephone call. What they're just getting is information about the location of the cell phones at various times. And there were questions about whether they would apply the Fourth Amendment to this. It's Carpenter against the United States. You've gone over it already. It was a criminal case, and they basically tracked an accused defendant according to these cell phones. The question was whether they had to get a warrant in order to get the information from the cell phone company. It's interesting to me, Bonnie, that the cell phone companies were somewhat divided. Verizon was the only one who really took a position. A lot of cell phone companies really didn't want to come in with a position.
And last time it was taken up, it was a split decision at the Supreme Court.
Well, yes, exactly right. And with the absence of Justice Scalia, and so they brought it back up. Now that we have a full complement.
David, tell us exactly what the Fourth Amendment says, because it's a fascinating amendment and it has really divided people in many different situations.
Yeah, it's basically, first of all, there are several things in the Fourth Amendment. One of the things that it covers is a protection of the individual against unreasonable search and seizure. And that is generally construed in many circumstances as requiring the government, if they're investigating you, to go to the court and make at least a first showing of probable cause, it's called, to say there's some reason to believe this person may have done something wrong, so please give us a warrant, and that allows us, for example, to go into your home.
What does this mean for further Fourth Amendment cases? Because this is just the beginning of it now. People will start to look for more protection of privacy potentially, or even less, maybe.
Yes, well, I mean, people will look for larger trends. I would be hesitant to say there are larger implications. I think the interesting point is how does it apply in the new internet world? Because after all, the Fourth Amendment had its origins before the country was founded, because British troops would break into people's houses in New England. And that's why they said we have to have some protection against that. It was just simply breaking into your house. It doesn't, they didn't conceive, of course, of the internet, of cell phones, of all the new communications mechanisms. So the real question is, the real Pandora's box are opening up. When do you have to have a warrant? When don't you?
And David, therefore, what does this affect in terms of the corporates? I mean, in terms of them getting more power, will we see any sort of market reaction, do you think, in some of the mobile phone providers and indeed Apple itself regarding the San Bernardino?
Yeah, you would know better than I would, frankly, as a practical matter. I mean, I think from the point of view of most cell phone companies, what they're saying is we just want to be told what to do, and we don't want it to be our fault. So we don't want to give over the records and then have a client sue us for invasion of privacy. On the other hand, we want to withhold information that's really critical in a criminal investigation and be in trouble with the government. So I think that's why most cell phone companies actually didn't come in. As I say, Verizon was the only one that came in. And because I think most cell phone companies are going to be in the position of just tell us what the rules are, and we'll comply with the rules so we stay out of trouble. So in that case, some clarity here may be helpful to the Verizons of this world, the people who have mobile phone operations.